Thank you, Kevin, for the for inviting us, making space here. So, my name is Diane Nguyen. Use she, her pronouns. I'm a staff attorney with Legal Aid Services of Oregon, the Portland Regional Office, and I'll let my colleague Garrett introduce himself.
Good afternoon, everyone. My name is Garret Wright. I'm a supervising attorney at Legal Aid Services of Oregon, also in the Portland Regional Office with Diane. And I also specialize in housing work there. And I use he, him pronouns.
That was my boss. Ms. Amy, do you want to introduce yourself?
Yeah, hey, my name is Amy. I use they, them pronouns. I'm a new staff attorney at LASSO, and I also specialize in housing.
Thank you, folks. So thanks everyone for joining us today, or folks who will be watching this later. We'll be covering today tenants' rights, as you can see from the slide, on topics being screening rules, habitability rights, and COVID-19 tenant protections, or what remains of them. Before we get into the meat of today's presentation, I also want to introduce folks to Legal Aid Services of Oregon, our organization, for those who are not already familiar. We are a nonprofit organization with 8 regional offices statewide that provides free legal help to low-income Oregonians. We focus on cases and matters that are to protect folks from their physical safety and access to food and housing. As we mentioned, we're from the Portland Regional Office, which serves 5 counties, which are Clackamas, Hood River, Multnomah, Sherman, and Wasco counties. So cases involving physical safety, food, and housing, what that looks like is typically we're taking cases that are, for example, family law cases that involve domestic violence, housing cases like eviction defense, housing discrimination, and there are also senior law issues comes up where folks are, seniors are having issues with long-term care facilities or facing elder abuse. We also take cases that helps folks get access to or maintain their public benefits, for example, SNAP or food stamps, Oregon Health Plan, or unemployment insurance benefits, for example. In addition, we also take employment discrimination cases, other types of civil rights cases. Now, with that introduction out of the way, I will, so this is an outline of today's topics that we're discussing. We'll start off by talking about screening rules. We'll talk about this at the statewide level. What are the rules that apply when a landlord screens a tenant who has put in an application for a tenancy? And we'll also talk about rules that apply to the city of Portland specifically. Next, we'll also cover some topics in habitability rights. Habitability is legalese for livable. So we're talking about these matters would matter to folks, for example, if you're facing like repairs issues or mold issues or rodent infestation issues. That's what we'll be sort of covering, the habitability rights. And then last, we'll do a brief coverage on what remains of the COVID-19 tenant protections, the majority of which has now unfortunately left us, but there are some residual protections that we want to make folks aware of in the time that it still remains. So with the introduction and that overview out of the way, I'll give it over to Garrett to start us off with talking about the statewide law that applies to screening.
Thanks, Diane. So the statewide screening rules, most of these are found in the Oregon revised statutes 90 point, let me just double check before I say it, 90.295. Chapter 90 of the Oregon revised statutes is where you're going to find a lot of laws related to landlord-tenant issues. And so these are the statewide rules that applies all throughout Oregon. And the core rules in here are that a landlord must provide a receipt for the screening charge. If they're charging somebody, they have to give you a receipt to prove that you paid it. A landlord may only require a single screening charge within a 60-day period. So if you're applying, with a property management company, they manage multiple properties. If you want to apply for multiple units within that 60-day period, they can't just keep charging you again and again for screening for different units. They should just be doing one charge, doing the screening once within a 60-day period. The screening charge must not be greater than the landlord's average actual cost or the customary cost. for comparable professional screening. So in other words, landlords shouldn't be using this as a kind of, profit-making activity. It should be only something that, is compensating the landlord for what they typically are having to incur to process your application, or what professional tenant screening companies would normally charge. A landlord can't require a screening charge if there's no unit available at the time the tenant applies, or if a unit is not going to be available in a reasonable time. The landlord must refund the screening charge if the vacancy fills before the applicant is screened, or the landlord doesn't conduct a screening at all, which of course makes sense because the landlord is not incurring any costs here, isn't doing anything. They shouldn't be able to keep the screening charge. And then if a landlord violates any of those provisions, the law says that an applicant potentially could sue a landlord for double the amount of that screening charge plus an additional amount of damages of $150. Next slide, please. So this is also still in terms of statewide rules under the same statute. So a landlord may charge a screening fee only if these 3 different requirements are met. So a landlord has to have adopted a written screening or admissions criteria. So it's not just something that's, criteria that's in the landlord's head or that they verbally tell you. It has to be put down in writing and is provided to the tenant. The landlord has to provide a written notice of the screening charge, so how much that charge is going to be, what the screening admissions criteria is, the typical screening process, your right as an applicant to dispute the screening information, appeals rights, if any. Some landlords say that you can appeal a decision, and here's the method how. A statement of non-discrimination policy, information about the rent and deposits for the unit, and whether and how much renter's liability insurance is required. And then the last requirement is that the landlord does now also have to provide actual notice of the estimated number of similar units in the area that they own and are available or soon to be available.
And then additionally, with regard to screening rules that apply statewide, there are restrictions on what a landlord may consider when they are evaluating an application. For example, a landlord cannot consider an eviction case if that case has been dismissed, or if the applicant had won that case, or if that eviction record of that case is older than 5 years. Additionally, a landlord may not consider an arrest if that arrest has not resulted in a conviction. However, there are big exceptions to this. For example, if the arrest had occurred and there are pending charges related to certain types of crimes, then the landlord can consider that arrest and that pending charge, and those types of pending charges for the crimes that the landlord may consider are drug-related crimes that are not marijuana-related, person crimes, so violent crimes committed against people, other individuals. They can also consider if they're sex offenses. They can consider if there are crimes of financial fraud, including identity theft or forgery. And then the really big catch-all provision here is they can consider any other crime if the conduct for which the applicant is being charged would adversely affect the landlord's property or other tenants, or the health, safety, or the rights to peaceful enjoyment of others on the premises. That's a lot of words and a lot of legalese. I think sort of I'll just plug a takeaway here with regard to all these screening rules is when a tenant is rejected, they should try to obtain in writing from the landlord the reason why they're being denied, so that they can look at and consider, if they're seeking legal help, is to find out the reason that I'm being denied. Is this a legal reason, or is this potentially something that I can challenge? To carry on from that is, sorry, now that I'm looking at it, I find it potentially upsetting that I used that picture for COVID-19. What I'm wanting to depict here is what remains of part of what remains of the COVID-19 protections for tenants. So under Senate and House bills that the Oregon legislature had passed in the previous years, in December of 2021, what remains of some of the protections, a lot of which had expired back in February of this year. But what does remain includes, for example, that from now until January 2nd of 2028, landlords may not deny any application because there is any eviction judgment, because of any eviction judgment that was based on claims that arose during the emergency COVID-19 time period, which is April 1st, 2020 to March 1st of 2021. I'm sorry, that should, yes, March 1st of 2021. And that includes not just non-payment termination notices. There could be for-cause notices alleging that tenants violated their tenant obligations under landlord-tenant law or under their rental agreement. Any of those eviction judgments, landlord is not supposed to be considering. And the other thing I want to note is that eviction judgments that arose during that time period there are potentially immediately eligible for expungement. And if folks have any questions about that, we'll talk about where to find resources at the end of the presentation. And the expungement process is really quick and it's free, and it's something that I think folks should really take advantage of if having an eviction record is something that's a existing or potential barrier that anyone has to finding housing. So additionally, the COVID-19 tenant protection that currently remains and is still there until January of 2028 is that a landlord cannot consider or cannot deny an application because of any unpaid rent that has accrued during the emergency time period. So that's April 1st, 2020 to June 30th of 2021. Lastly here, a landlord may not consider whether an applicant has a medical marijuana card or if that applicant is a medical marijuana patient.
So now we're going to talk a little bit about some of the screening rules that apply if the rental property is in the city of Portland. So the city of Portland, as folks may know, a couple years ago passed the Fair Access in Renting ordinance, or the Fair ordinance, and City Council spent a lot of time developing the ordinance and got a lot of feedback from tenants and tenant advocacy groups about it. And so we're going to talk about, it's a pretty lengthy ordinance. There's a lot in it, but we're going to try to talk about some of the main parts of it today. I want to put a plug in. I think we mentioned at the end of this as well, but we have some handbooks, renters handbooks on several of these issues, including I think like a 10-page handbook on the Portland relocation. I'm sorry, just on the Portland Fair ordinance. On the website, which is called OregonRentersRights.org. And you also may be able to find some of this information on OregonLawHelp.org as well. But in Portland, landlords in Portland, and there are some exceptions to this. This doesn't apply to every single landlord. So some smaller landlords are excluded from this. But in general, probably many landlords throughout Portland would be covered by this. And if there are two parts of the ordinance that are requirements for the landlords covered. One of them regards landlords and their ability to ask for forms of identification. So in Portland, the forms of ID a landlord must accept are the following that we have listed here. So that could be evidence of a social security number, valid permanent resident alien registration receipt card, immigrant visa, individual taxpayer identification number, ITIN, non-immigrant visa, any government issued identification regardless of expiration date. So that means if you have a driver's license and it expired 10 years ago, that's an acceptable form of ID here in Portland. Any non-governmental identification or combination of identifications that would permit a reasonable verification of identity. And one of the key points here is that in general, applicants cannot be asked about their immigration status. So it has been outlawed basically in Portland for landlords to inquire about someone's immigration status. The one exception I would say to that the ordinance does state is that if the housing is a form of some type of subsidized housing where there may be a requirement that there be a verification done of a tenant's citizenship or immigration status, then that may be a permissible question. But if it's not some type of subsidized housing with that type of requirement in the funding, then landlords cannot ask about someone's immigration status. The required application form. So landlords, again, this again is a kind of across the board part of the ordinance. So landlords, when they're distributing application forms or having them on their website, they have to include several additional documents besides just the application form. So one of them is a notice that notifying applicants of of an option to state whether or not they have a mobility impairment or other disability status. And one of the reasons for that is because, again, under this ordinance, tenants that have mobility impairments or mobility disabilities may have certain rights in terms of being able to have prioritized access for accessible dwelling units. And so this is a form that landlords are required to provide to tenants so that tenants can provide that information if they choose to do so. And that might then enable the tenant to then get priority status for an accessible unit. They have to provide a notice of tenant's rights, which includes that the tenant's right to seek a reasonable accommodation or a modification to a unit under fair housing law. The landlord screening criteria and evaluation process, and whether or not the landlord charges an application fee. And then there has to be an option in writing provided to the tenant that to explain that the tenant has the option to explain any negative rental history. And this is kind of a proactive way of landlords letting tenants know upfront at the initial application stage that if a tenant feels they may have something in their rental history that may have a negative impact on their application, that they can provide additional information to try to clarify that or qualify that or provide mitigating evidence about the circumstances involving that history. And then again, this is Portland specific. So landlords in Portland, they have two options in terms of the screening criteria. They have to pick one of the two. One is to use the city's low barrier screening criteria, which is all of those criteria are listed out in the ordinance. And just in general, what that criteria does, it restricts a landlord's ability to deny an application based on certain criminal history, certain rental history, and certain credit history. So it doesn't completely say landlords can't consider any of these types of histories at all, but it does put some, pretty significant restrictions on the types of crimes that landlords might be able to consider. It restricts the window period for looking back at evictions, I believe from 5 years to 3 years, and then restrictions regarding kind of, what a landlord can deny someone in terms of, say, a credit score. So landlords can choose to use that process, or they can still use their own screening criteria that they've developed. But if they do that, then the ordinance requires that they conduct an individualized assessment that it considers an applicant's explanation regarding negative rental history. And that really kind of comes out of a lot of these struggles over the past several years by many tenant advocacy groups and civil rights groups to push fair housing enforcement against landlords that were denying housing to tenants that were members of protected classes, including BIPOC tenants and immigrant tenants, for things like criminal history or credit history. And so it's a way to the city here. I think what they were trying to do was trying to bring this fair housing concept of saying you cannot just evaluate someone's application and can't have just these barriers to housing, like say for instance a felony ban that says anyone with a felony automatically cannot be accepted for housing, and saying that would have a disparate impact on certain tenants, including BIPOC tenants. And so to have a requirement like that would result in discrimination being furthered. And so this is a way to try to address that. But landlords, again, have these two options to use when they're considering an application.
So this slide, continuing with the Portland specific rules regarding screening, there are limits to how much a landlord can charge for the screening fee, the screening charge. So if the landlord wholly uses a professional screening company for all of their applications, then the landlord cannot charge more than what that screening company charges. If the landlord both charges or both uses a professional screening company for some, but not all the applications. And so they might conduct some of the other screening on their own and other methods not using a screening company. Then the landlord cannot charge more than 125% of what the screening company charges. And lastly is if the landlord does not use a professional screening company, then they cannot charge more than 110% of the screening company's charge. This next slide here depicts, so when folks are applying for housing, oftentimes they'll see that the landlord says that they must have a certain amount of income in order to qualify based on that ratio of income to rent. And in the city of Portland, these numbers are set annually. And I've updated this chart. It looks slightly different from last year to reflect the current numbers, which we anticipate changing soon in the spring when the city of Portland puts out the updated numbers. So how this chart is used here is we're looking at the figure on the right. It shows the rent that's deemed affordable, which is rent that's deemed affordable to those who are making 80% of the median household income for the area. So based on the number of bedrooms that the person is renting, this is the amount of rent that is deemed affordable for those who are making 80% of the median household income. And if the rent that the landlord is charging is less than that amount that is deemed affordable, then the landlord can require that the gross income of the household has to can be up to 2.5 times more than that amount of rent. And if the landlord's if the household income, or sorry, if the rent is more than the amount that's there, then the landlord can require that the income be at least up to twice as much as the rent that's listed, that's deemed affordable. So just to use a round number to make it a little easier, let's say that for a 1-bedroom, the rent that's deemed affordable is $1,000. If the landlord is charging $900 for a 1-bedroom, so that would be less than the amount that's deemed affordable, then they can charge up to 2.5 times they can require that the applicant's income be up to 2.5 times more than the amount of rent that they're charging. So 2.5 times 900. And if they're charging more than the 1,000, that is the rent that's deemed affordable, say they're charging 1,100, then they can require that the income be up to twice that amount. The thing also to note with regards to the income screening is a landlord, for example, if there are multiple tenants applying together, that group of applicants can decide whose income they want the landlord to screen. Let's say one person alone income qualifies and they don't want these other folks to have their credit history dug up or looked at. They can limit the landlord to just screening that person that they've identified for credit or income qualifications, although the other applicants would also be screened for rental history and criminal history. Okay, next thing here is in the city of Portland, for folks to be aware of certain timelines that applies to when they're applying and what it might look like when they might be able to appeal. So within 2 weeks of the landlord doing the screening, they must provide a written decision to the tenant. So that's the difference between state law and the local Portland law, where state law does not require the landlord provide the decision in writing. But as we mentioned earlier, it's always helpful anyways to request the information in writing, even if folks are outside of the city of Portland, just so that they have written documentation of, if possible, what is the reason for the denial and to look at potentially whether or not there are grounds for challenging it. Additionally, so the landlord, after providing that written decision, they must provide 30 days for the tenant to appeal that denial. That process might look like, for example, submitting letters in support. I don't think have time here to cover all of it, but reasonable accommodations, for example, if folks have disabilities that might have caused them to behave in a certain way that resulted in bad credit history or rental history or criminal records, if it's disability related, for example, that might be a reason for them to try to obtain a reasonable accommodation request and exercise their rights under fair housing law, anti-discrimination law in housing, in order to have that reconsidered. So that is some things that might go on during the appeal process. The other thing to note is that an applicant who successfully appeals will pre-qualify for units that open up for the next 3 months, and they would not need to pay a new screening fee. All right.
So our next section here is on habitability rights. Now there's different parts of Chapter 90 that talk about habitability rights. This part here we're talking about is you can find it in ORS 9320. And so a unit is not considered habitable if it substantially lacks, and that can be key. Does it substantially lack, as opposed to something that might be relatively minor, right? But substantially lacks any of these things, and these are just examples. This is from the statute, but this is not exhaustive. There could be other habitability requirements you could argue exist, but definitely includes heat, working plumbing, hot and cold running water, safe drinking water, gas or electricity in safe working order, light fixtures that function, functioning locks for your exterior doors, latches for windows, working appliances if those appliances are supplied by the landlord, which they often are. So if your refrigerator breaks down and it was there, it's a appliance that your landlord had there when you moved in, then landlord's got to fix it. They can't make you repair it or make you buy a new one or something like that. Waterproofing and weather protection of roof and exterior walls. We see this a lot. There's a lot of issues in Pacific Northwest with housing that has got real serious issues with mold, and we see lots of leaks, water leaks, and intrusion into windows and doors, and black mold and things like that in cases all the time, unfortunately. And working smoke alarms. And again, these are just examples, but these kind of cover a lot of the key requirements for habitable housing. So what should a tenant do if you have a repair problem, and it seems like you're concerned your landlord may not be responsive to it or has been responsive to it? Well, again, I'll just point out we have a handbook on rent, the renters' rights handbooks on OregonRentersRights.org. We've got a handbook on repair issues, and it has some sample letters and things like that you can consider sending to your landlord. But here are some of the initial steps we kind of recommend. Always encourage you to keep records of the issue by taking pictures and videos and making sure you save those. Those might be, one, obviously you can provide those to the landlord right away so they can see the extent of the problem. But two, if push comes to shove and you might at some point have a legal claim against the landlord for failing to timely come and make the repair, you're going to want to have those videos and photos of those conditions, because you might be filing a lawsuit or taking other legal action potentially. Whether in small claims court or with an attorney. So having that evidence is really crucial. Tell the landlord in writing about the repair needed, the date of the request, and then a reasonable deadline by which the landlord should respond, and keep a copy of that. I think, I used to always tell tenants, like, best way to do it is to have a letter, mail it to the landlord, keep a copy. I mean, I think nowadays, email is so much in use. I think the laws don't require you to necessarily in some instances to do a mailing. But I would say that if I were to recommend something, I would say the safest bet to do it would be to have a written letter, print it out, put it in the mail, first class mail to the landlord's address, make it, keep a copy of it, take a photo of the envelope. And then you can also, take a copy of that and email that to the landlord too, have an electronic backup. But I would always say just cover your bases, just to make sure it's clear the landlord got the notice, that they're not playing around later saying, well, that email address didn't work anymore or whatever. I would try to do, if you can, do both. And then deliver a repair request letter. And got ahead of myself. Deliver the repair request letter in person or in first class mail. You don't want to do certified or registered mail. And the reason is that the when the Chapter 90 talks about requirements for landlords giving notice to tenants and tenants giving notice to landlords. And one of the things it talks about is when written notice is required, generally it has to be first-class mail. So it's not considered valid, even though, sometimes it seems like, well, sending it certified mail or registered mail is like a more secure way, or it's going to be more guaranteed that we'll have proof the landlord received it. For whatever reason, the legislature decided not to authorize those forms of giving notice. They said very clearly it has to be only first class mail. Now, if you want to do an additional mailing that's certified or registered, you could do that. But you definitely, if you're going to mail it, always at least one version of it, do it by first class mail for sure.
So in this very text-heavy slide, I'm going to dovetail off what Garret just shared. And the importance he was outlining, the technicality under the law about what is contained in a notice and how is provided to the landlord. Like Garret just mentioned, the notice has to be in writing, and that's the old-fashioned way, meaning a physical letter, not just email or texting it. And the methods of delivery are to either hand deliver it or to send it by first class, or if your rental agreement allows it, pre-posted on the landlord's, or probably usually it's in practice is to take it to the office and then also to mail a copy. But the reason why, even though practically speaking, I think my recommendation usually to folks is to take a picture of, if they're using text to communicate, is to take a picture of the letter that they're sending and text that and then send that letter as well. And then in the text, or if you're emailing it, in the body of the email or the text to state that I am also sending this by first class mail. So that's a practical matter. You want to get the notice or this repair request to the landlord as soon as possible. But at the same time, you want to do it in a way that allows you the fullest access to the range of legal remedies that you might have available to you. So in this slide, the remedies that are covered here, and I'm going to talk about some other laws that apply in the following slide, but here, these are the remedies that apply when what has happened is the landlord has intentionally or negligently failed to supply an essential service. And in the bottom or on the right there, I define what essential service means under the law. So that's if the landlord has intentionally or negligently failed to supply heat, plumbing, hot or cold running water, gas, electricity, light fixture, on and on. These were the ones that were covered in that prior slide when we had a little more visual than this text heavy one. In any event, so if the landlord has intentionally or negligently failed to supply an essential service and the tenant has provided written notice, right? So something in writing in the method that we've prescribed here, or the law has prescribed here, then these are the remedies available. The tenant can seek substitute services. So for example, if your heat went out and it's in the middle of winter, you're needing to buy a heating unit in order to stay warm, or say your fridge has went out, you're needing to, I don't like that example of the fridge, so I'm just going to redact that one and carry on with just the heat one I just left there. Okay, but so if you, for example, need to buy that independent heating unit, you want to keep the receipt, and here's the amount of money you've paid in order to obtain this substitute service, and you can seek to recover that from the landlord. You can also recover for what's called diminished rental value. The idea being that you paid your rent. This is you bargaining for the full deal here, package of the housing here. Let's say the heat goes out or the water's not working. You're getting less than the deal that you had bargained for. So what the claim you would have against a landlord is what's called a diminished or a reduced rental value claim. Additionally, if the lack of that essential service is so serious that it causes the unit to be unsafe or unfit to occupy, then you can look for substitute housing and then to reclaim that cost from the landlord. So for example, if you, in the middle of winter, lost heat, can't possibly stay here, otherwise you're gonna freeze, maybe you need to go to a motel and stay. You wanna keep the receipts of those motel expenses, including even for like food that you're having to buy out of pocket because you're not having access to your home where you're able to cook in your kitchen. keep those receipts of the expenses, and those are costs that you can recover from the landlord, for example, by deducting that from your rent beforehand. But the important thing to know in trying to access any of these remedies is that you should have beforehand given written notice to the landlord where you specify the way in which they had breached, and state that these are the remedies that you are seeking as outlined here: the substitute services, diminished rental value, or substitute housing. Additionally, for most tenants in this housing market where it's so hard to find anywhere else to go, I think realistically speaking, most folks would rather hunker down with the issue and rather than to terminate their tenancy. But for those who, for whatever reason, the circumstances are such that they're like, it's so serious and maybe I have somewhere else to go, I just want to terminate my tenancy. So let's say you're on a fixed term lease and you can't just get out easily. Well, if the lack of that essential service poses what's considered an imminent or serious threat, then you can give the landlord a 48-hour notice to terminate that tenancy. And the landlord, if they do not adequately remedy that breach or that violation of their duty to provide that essential service, within the 48 hours, that tenancy will terminate. So issues that usually might come up like that, for example, is if the front door or maybe windows are broken, front door lock is broken or not working, it's not safe for the tenant to be staying there where anybody can be coming in, or if there's sewage in the house, or if there are severe leaks, or maybe there are rodent infestations that there's a citation from the city that shows, or there's records from your doctors, something that records to show that this is a serious problem that's really affecting health very seriously. Something like that would most likely make that remedy of terminating the tenancy available to the tenant. Excuse me. And then I highlighted that there are other remedies that are also available, or other laws that also apply, even if, for example, the issue doesn't rise to the level of being an essential service, or if the tenant had not given written notice. So if it's not an essential service, but there's still a habitability violation, what a tenant can do is they can provide a 30-day notice to terminate, right? So because it's not as essential as what we just covered, not life-threatening, there isn't an imminent or immediate threat, there's more time for the landlord to potentially remedy that breach. It would give the tenant, it gives the landlord more time to remedy the breach, and the tenant would need to provide more additional advance notice before terminating the tenancy. In addition, so the previous slide covered what we call written notice. Under the law, there's also what's considered actual notice. So in any way that the tenant lets the landlord know. So if it was a phone call, it was an email or a text, and you have good records of these things actually happen, even if they weren't written, then tenant would have a better ability to prove that the landlord knew or reasonably should have known of the issue existing. And if the tenant was not responsible for the issue, then the tenant may sue the landlord for the actual damages, or what's called injunctive relief, which is an order from the court to essentially fix the issue here. Additionally, if the tenant had given notice to the landlord, due to kind of just length and the details of time, we're not getting into really specifics here in our handbook. Like Garret kept mentioning, we have it broken down, but I think the thing to flag here is sometimes we have what are like considered under the law minor habitability defects. So these are repairs that would cost less than $300 to fix. For example, maybe there's a broken closet doorknob, or there's a light bulb that is out. It would cost fairly, or maybe there's a plumbing leak or a toilet plug clog. So fairly cheaper to fix. If it's under $300, the tenant can give notice to the landlord of the problem, let them know that they intend to have this fixed by a professional. If the landlord doesn't respond within whatever amount of time, set them a reasonable timeline to respond. If the landlord doesn't respond by then, the tenant, it's important to hire someone to do the work and keep those receipts, and not for the tenant not to do the repair on their own. And then what the tenant can do is deduct the expenses that they've incurred from the following month's rent. Citation for all of those laws are at the end of each of those statements there. And the last thing that we'd like to remind folks is that the law prohibits a landlord from retaliating against a tenant who has made a good faith complaint about their tenancy. So that's why I think written notice is important for not just the reason that it makes you or allows the tenant more access to different types of remedies, but it also creates this paper trail. You're doing this documentation of I've reported this issue. If the landlord at some point turns around and either raises your rent or issues a termination notice or even threatens to do those things, that could potentially be grounds for a retaliation claim. So that's just to highlight the importance of creating and keeping a paper trail of your communications with the landlord.
So now we'll talk a little bit about the remaining COVID-19 tenant protections that exist. And then the one caveat I'll say is that, what we're going to cover is the state of the law right now, or the main parts of these laws as they exist right now that are related to COVID. But the law can change, and the law has changed several times over the past 2 years. There's been different versions of eviction moratoria that have existed. And it's possible that if I know right now it seems like COVID numbers are starting to go back up again. At least I've seen that in Multnomah County. If there's another surge or something like that, or more deadly wave of COVID that may occur, then it's possible the legislature might reconvene and create new tenant protections. I don't know, but I just want to mention that because it is the type of thing where the law can change, fairly frequently. Most of these protections have been in place. The last major law changes occurred, probably about a few months ago. But it is just something to keep an eye on, and we do try to update our information on Oregon Renters' Rights and Oregon Law Help about new laws that come into effect pretty soon after the laws are implemented, and have fact sheets on them. So that's a good resource for folks. So some of the main protections here is that until June 30th of 2022, tenants may give their landlords proof of application for emergency rental assistance in order to avoid being evicted for non-payment of rent while the application is pending, or until October 1st, 2022, whichever is sooner. So let me unpack this a little bit. So application for rental assistance. So, there had been, as folks may know, there's basically kind of been two pots of rental assistance funds, really. One was through the state, through the Oregon Housing Community Services, OHCS. That had an online portal. That portal has now been closed, I think, for several weeks now. So tenants cannot apply for rental assistance through that online OHCS portal anymore. However, our understanding is it sounds like there may still be some community organizations that may still have some rental assistance funds. And the best way to contact those organizations is if you're in Multnomah County, calling 211. Or trying to reach out to, in your county, whatever if there's a main central number for connecting with things like rental assistance or utilities assistance, giving that number a call, and they hopefully should be able to potentially connect you with a service provider that may still have rental assistance or be taking applications. But if you've done that, so if you have applied for rental assistance, just the act that you've applied and getting some type of confirmation back from the agency you've applied for, a confirmation email or a printout or something that's showing that you've completed the application and now they're in the stage of evaluating it, that can put a freeze still on the any type of non-payment eviction case moving forward. So if the landlord takes a tenant to eviction court for non-payment of rent and then gets paid for the rent demanded in the termination notice, then the pending eviction case must be dismissed. And that's also different than the way the law was pre-COVID. The law pre-COVID was if a tenant got a termination for non-payment of rent, usually those were often a 72-hour notice, not a 10-day notice. then usually the tenant had to pay all of that rent within the 72-hour period. If they didn't, then the fact that the tenant showed up at court for say their first court appearance with all the money in hand didn't mean that that was necessarily going to resolve the case, because the landlord could lawfully say, you didn't pay me within the 72-hour window period, I don't have to take it now, and I'm going to evict you, I'm going to move forward with the eviction. So the law now is better for tenants, because it says that as long as the landlord gets paid that money that's in that non-payment notice anytime before a judgment in the eviction case is entered. So basically, for most people, that's going to be before you've gone to trial and lost at trial. It can be the morning of your trial, getting ready to start. You could show up in court with all the money. If you do that, then the landlord has to take it. They can't refuse it. And then the court is instructed to dismiss those cases. Tenants can give their landlord proof of their application for rental assistance in a variety of ways. I was putting in the chat, that can be by email, by text, letter, screenshot, or any other reasonable method is what the law says. I mean, any other reasonable method to show the tenant has actually applied. And here's a cover letter, and where you can find a cover letter that's a tenant can send to the landlord. Other new requirements, this is through September 30th of 2022. So I've seen this already. It used to be a 72-hour notice generally. Now it's 10 days. So we still see some landlords that don't realize this is still in effect, that a tenant has to be given 10 days from when the notice is issued to pay the rent, not this, basically 3-day period. So some landlords are still issuing defective notices with less time. So that could be a defense to your eviction case potentially if the landlord didn't give you a 10-day notice for non-payment of rent. There's also this rider here of your rights as a tenant, that again, this is just for non-payment of rent eviction cases. So not for, if the landlord alleges that the tenant's violating their lease by having too many belongings on their patio, or there's a noise complaint or something like that. Those are different types of cases. Those are for cause cases alleging there's a violation by the tenant of the rental agreement. So what we're talking about here doesn't apply to those type of eviction cases, but these do apply to cases where what the landlord is trying to do is sue you for non-payment of your rent. So if that's the case, then there's this rider here, and that's the language that has to be included in the termination notice. If your landlord doesn't include that in your termination notice, again, that might be a defense to your eviction case. Tenants have rights. Resources are available. OregonRentersRights.org. Yeah, Diane, I'm sorry. I wasn't sure which of us was doing the slides. So.
Sorry, no, I would have said the exact same thing. Read from the slides. No, but we've been highlighting that we have resources available, and this is where to find them. That's the website that's maintained by our office. It's just a little, this is a screenshot from the landing page. The big red button up top, you click into that, there will be languages or handouts, info sheets in various languages, I believe English and 10 non-English languages that covers the current COVID-19 protections in more detail that we just sort of highlighted there. In addition, there is a eviction defense project that's been recently created with the intent of, as much as possible, providing tenants defense in eviction court. The contact number, and the email is provided also on that page. And I think the thing to note is, if for folks outside of the city of Portland, the program, which is administered by, is a joint project between the Oregon Law Center, which is a sister organization of Legal Aid, and with Legal Aid. So these are folks who take just eviction defense cases. And so for folks outside of, Garrett, please correct me if I'm wrong here, is outside of the city of Portland, you have to wait until there's a case filed in order to contact them to get assistance. But if you're in the city of Portland and you've received a termination notice, you can still contact to get advice on that notice. There are also other various community organizations or resources, free eviction defense resources in Multnomah County. And if you have any need for referrals, you can contact our office for that as well. And in addition, this is housing self-help guides. Again, this is a screenshot of that landing page. If you go there and you scroll down, you're going to see all those repairs handbooks that I had mentioned. I wonder if I can just pull it up now. Due to my tech limitations, I'm not going to try to pull up the website now, but if you pull it up, you're going to see really quickly a lot of handbooks on common landlord-tenant issues. For example, I mentioned reasonable accommodations. So folks with disabilities might want to be interested in taking a look at that. If you receive a termination notice, we have a very detailed termination and evictions handbook to break down how to look at your notices and find out if there are potential defenses, if there are defects in your notices. The repairs handbook that we've been talking about related to the habitability rights. There's a mold handbook, rodent infestation handbooks. The rights under those are very similar to the repairs ones. So do check out that website. Oh, and I think I really want to highlight the eviction expungement handbook. Some folks may be familiar with Mateo, another colleague of ours who helped to put together that handbook, which I think is just a very useful tool that can have such great impact on folks to be able to remove this barrier to housing by expunging or erasing old records. Thank you, Garrett, for dropping all that in the chat. Okay, I'm kind of rambling on. So just in summary, please check out that website and see if any resources might respond to your needs. And thank you. Questions?
Awesome, guys. Thanks so much. There was a ton of really great info, actually. Actually, even some stuff that I didn't even know about. So thanks so much for that. Looking through the questions in the chat box, looks like there was one, but Garrett, you already answered it. So thank you so much for doing that. Are there any other questions? We definitely want to open it up for folks. We've got, honestly, the experts in front of us. So, if anyone wants to ask any questions now, it is a fantastic time to get those answered. Also, just to let folks know, we do have our survey. I'm letting just a reminder of that. The link is also in the chat box as well. Again, if you can tell us how we did, we love that kind of feedback. It's really helpful for us. And any questions whatsoever?
I feel like the question that was asked in the chat might benefit some of the other people that were here, as far as if you get to the point of someone threatening you with eviction, and how to properly respond to that in a timely manner so as to say these claims of yours are false against me. Like my specific situation is someone claiming that they didn't receive rent that I did send, and having proof. When I heard that certified letters weren't allowed, I was like, uh-oh. So that might be helpful for others. I don't know. Thank you for this stuff.
Yeah, of course, you're very welcome. Did the presenters, did you guys want to elaborate on that a little bit?
Sure, I can try. Yeah, I mean, so like I was saying a bit earlier, that the statute talks about, basically the statute talks about two types of notice. One is actual notice and one is written notice. And so when anytime any of the provisions of the Chapter 90, which is the Landlord Tenant Act, say that some type of notice has to be given by written notice, that always means first class mail. So you always want to do that by first class mail. Like, so for instance, Diane was talking earlier about a tenant's rights to send a written notice to terminate their tenancy on 48 hours notice because you don't have like heat or hot water, right? So that's something you have to do that by first class mail. It's not going to be effective. It's not going to be legally effective if you send a text message or an email, or if you send something certified or registered mail and not first class mail. A court is not going to say that you gave written notice to the landlord. So you want to make sure that, depending on which kind of batch of rights you're asserting, that you're kind of doing what the law requires. So for most types of things where you've got a serious dispute with the landlord, I would say, you're never going to go wrong by sending it first class mail. You can also send it by email. You can also send it by fax and also by certified, but always at least do it by first class mail. There are some situations under the law that say a landlord doesn't need written notice, they only need actual notice, which then that might mean like an email, right? Or verbal notice. Although I never recommend just doing something, providing verbal notice, because every time the landlord's just going to say later in court, right, if it gets to that stage, they're just going to say, well, no, the tenant never told me that. I never had that conversation about that repair issue in their apartment that day, you know? So always you want to put it in writing, but I think the safest way to do is always like first class mail. And like I was trying to say, there is that distinction there about, you know, protections under SB 891. The legislature tried to make that something that was as broad and easy as possible for tenants to assert their rights, so that tenants didn't get bogged down in, well, you have to notify the landlord in this particular method. So it's great that the legislature allows that for asserting, basically notifying the landlord that you're applying for rental assistance to put the brakes on an eviction case. But that's really the only kind of main situation I would say that where you've got that flexibility. I would always err on the side of the first class mailing.
Very cool. Thanks a lot for that, actually. Any other questions for our presenters today? Okay, I don't see any other questions. Again, thanks so much, guys. We love having you. Always a pleasure to partner with you. There was a ton of great information. Really appreciate it. And I hope you guys get to enjoy the beautiful weather outside and have a fabulous weekend.